It decides what the terms of reference will be. It does not even appoint, it doesn't even have to appoint the RAC. It does not have to follow the RAC's advice, and does not have to even read or consider the RAC's report. So I think the assurances they're giving people by saying, don't worry, we're going to have these regional advisory committees, is hollow. The other thing too, and I won't get into too much detail on this, you can read my paper or other materials I've written. This is the paramountcy clause. Section 17 sub 4 says if there's a conflict or inconsistency between this act or any other enactment, this act prevails. So this legislation prevails over every other act in Alberta and any protective provisions that are in it that are inconsistent with this. So a summary, Cabinet now has the power to extinguish existing rights including water licenses, land titles, mineral titles, grazing leases, development permits or any other form of permission granted by government. It assigns the Cabinet the role of central planner for all regions of Alberta, overrides local decisions, municipal decisions, removes rights to compensation, and the role of the courts to protect the property of individual business rights are removed by the Act. Well, maybe I got all this wrong. When I spoke at the legal conference that I told you about at the start of this talk, or the Twilight Zone part, I wasn't the only speaker at the legal conference. Some of you may know was there, Maurice Seiferling. Maurice Seiferling is the Assistant Deputy Minister. He is the Stewardship Commissioner under this Act. He went first, I went second. I spoke to the bar, was speaking more as a way a lawyer would speak to other lawyers, but my comments were clear about the legislation. And I asked the chairman to provide Maurice with an opportunity for rebuttal. Normally we don't do that at a legal conference, but I said, let's break with tradition. They said, great idea. So Maurice walked up to the podium, and he said the worst thing he could have possibly said. It sent a chill down my spine. He said, what Keith Wilson has described to you as the features of Bill 36 is accurate. And then he asked me as he was leaving, and he went on to explain why the Cabinet thought it was good to have all these powers, and that why they should have political accountability and not accountability to the courts. And he went through all of these rationales that didn't create any satisfaction with the lawyers assembled. But as he was leaving, he asked me if I'd email him my paper. I did, and I didn't expect a response, and he responded. And he said, hi Keith, thanks for a copy of your presentation. With respect to ELSA, that's the Alberta Land Stewardship Act, Bill 36, the individual comments in your paper, I believe, are correct. Okay? And again, at this point I thought, is this guy trying to antagonize me? You know, why isn't he saying, oh, but you know, we really didn't mean that and we'd never do it? But then he goes on to show that he actually read it, because I made a couple of little minor irrelevant errors that he brought out, and I error noted. He says, except that ELSA does not divide the province into 7 regions, as the paper suggests, nor are they land use regions. My apologies. Section 3 gives the LGC, Lieutenant Governor Council, the Cabinet, the authority to establish integrated planning regions. The number, geographical area, etc. are at the discretion of the Cabinet. Point noted. In other words, I didn't get the extinguishment powers wrong. I didn't get the no compensation wrong. I didn't get the removal of the courts. I didn't get the stripping municipalities of their role wrong. I got some of the details wrong. And I shouldn't have made those minor mistakes, but I did. As somebody pointed out to me, this illustrates at least that he read my paper. I think the critical part is he says my paper is accurate except for that. So, where are we? Remember the dots I said about compensation? There is a provision that says you can get compensation under a conservation directive. The reason I don't get into that is, well, first of all, it's voluntary. The Cabinet doesn't have to use the conservation directive. A conservation directive is an order from the Cabinet that a landowner can't do certain things on his land under these specific sections in Part 3 and Part 3 of the Act. And that order entitles you to compensation. But the Cabinet has a choice. They can either use their Section 11 powers and extinguish your title and no compensation, no courts. I call that the shotgun. Or they can use this hammer and say, bop you on the head, we're going to restrict your land use, but we're going to let you have compensation. I'm glad they made the hammer. I can't get past the shotgun, if you follow me. I don't think the problem's this conservation directive mechanism, although there are some issues with it. I don't have a problem with the conservation directive. The problem I have, and other lawyers have, and other people have, is that the cabinet's given itself these other powers. They also say, well, wait a second, there's compensation provided under other acts. And I won't take you through the detailed analysis. I've got slides that show it. If somebody wants to, I can. I've written it up in my response. I mentioned a little while ago that the government finally has written something in response to what I've been saying. They released that on Friday, or at least I received it on Friday, and I have finished a response to it, and or my reply to them, and I expect to have that finalized this afternoon, and I'll make that available. In short, the government's written comments from last week demonstrate that they intended to give themselves these broad extinguishment powers. They defend the fact that they've done so. It confirms that they intentionally did not want you to have rights to the courts. And it shows to me that they don't understand a clue about how compensation systems work. They just don't get it. They think Section B actually means something, and once you've read my legal analysis, you'll see how it doesn't mean a thing at all. I'm not going to take you through the minutiae of it because it's just too much information, but I stand by my conclusions. This was me going to be taking you through it, so I'll skip these, and I'll get up to near the end here. Well, what about the Bill of Rights? And I think you need to understand this, and you need to know they're also saying it. The Bill of Rights, there's the Canadian Bill of Rights, and each province has a Bill of Rights. And the Bill of Rights says, basically, you can't have your government can't take your rights away from you except by the due process of law, okay? But the courts have said, in the Trellenberg case, which is the leading case in Alberta, which adopts several lines of authority from our Supreme Court of Canada, that if a statute contains words that allow land rights to be taken without compensation, which clearly Bill 36 does and is intended to do, and that same act says you are not entitled to compensation, the Bill of Rights says you're not protected. I'm not happy about telling you that, but that is the law of Alberta and Canada. The Bill of Rights is a shield, not a sword. That's how it's described. It doesn't create rights. And if a statute says your property can be taken without compensation, then your property's been taken by due process of law. And that's what how the courts have interpreted it. Again, it wouldn't be my way to interpret it, but that's what the courts have said. So when the government says, don't worry, you still be protected by the Bill of Rights, that's legally false. There is no legal authority to support their position, and the clear legal rulings from our courts show that the government is wrong in that statement. So at the end of the day, Bills 19 and 36, and I saved you the misery of 19, allow property rights to be taken without compensation, and therefore the Bill of Rights doesn't protect you. Nor does the Charter. I get this question all the time. The Charter of Rights, when it was repatriated in 1982, when the Queen came over on that windy day and Prime Minister Trudeau was there, leading up to that day, the Western provinces, Lougheed and others, wanted property rights included in the Charter of Rights. Economic rights and property rights were not ultimately included. So you cannot rely on the Charter to protect yourself against this legislation. Under our Constitution Act of 1867, powers are divided between the federal government and the provinces. So the federal government has military and a bunch of other things, and the province has jurisdiction in other areas. One of the areas that provinces have jurisdiction under Section 9213 is property and civil rights, and that's why we have a Land Titles Act, and Saskatchewan has one, and BC has one. So essentially, you own your property, you have your rights to carry on your business at the pleasure of the government sitting at the day. The critical point is that all provincial governments have included protections in their laws so that citizens' property cannot be taken arbitrarily, compensation must be paid, and provide protection through the courts. But that is no longer true for Alberta. So the law books that they teach first-year law students at universities now, if this legislation isn't repealed, are going to have to be amended. And after they're going to have that big statement about these are the basic principles in a Canadian democratic province.